Hey guys, this is Sharon Justice Black. I'm a Texas Public Insurance Adjuster, license number 1949752. I want to talk about the Texas Department of Insurance Commissioner's Bulletin number B-0035-10, and 10 means 2010. So it was August 31st, 2010 it was put out. And let me see if it has a updated 3/23/2020, so even 10 years later it was still in effect, and probably still now because it's on the commissioner's website. But the Texas Department of Insurance issues this bulletin regarding the misdirection, misapplication, and improper use of insurance claim settlements. So as you know, when you get a claim settlement, they may put your mortgage company on there as a lost payee. But even if you have an attorney and the lawsuit gets settled, there's now a bulletin that states that even if your attorney settles a lawsuit for you, and they should not settle it unless you gave them permission, every time money's offered, they have to offer it to you. They can explain it to you so you can make a decision. No, turn it down, take it. What does that mean to me? After fees and expenses, what am I getting? But insurance is, I guess this has come up, that representatives, and I say it could be a public adjuster, an attorney. I can't imagine somebody else getting your, maybe a mortgage company, but it would come to you first, getting your check or getting a settlement and you not knowing about it. So there is now, I think what happened is the state bar stepped in and said, hey, we've had complaints that people have said, hey, my lawyer took a settlement. I didn't even know anything about it. I'm finding out later and I never got any money. That happens car wrecks, and it also happens in homeowners. So the department strongly encourages the insurance companies who are issuing the settlement payments, whether that's in a lawsuit or outside of a lawsuit, payable to both the insurance claimant and the claimant's representative. So see me as a public adjuster, I'd be your representative. My name would go on the check, but so would a law firm's name. They're to provide written notice. This is the insurance companies, to provide you written notice at the same time the payment is being made to that representative. And such notice should state the amount and method of the payment and the name and address of the party to whom the payment is made. So usually I will get an email to me and my client that will say, hey, here's a payment letter. This is how much we're sending. We're putting these names on the check. Could be me, the homeowner, and the mortgage company. It could just be the homeowner and the mortgage company. It could just be me and the homeowner. So they will say, and we're going to mail this check to, Sharon Justice Black at my address here in Spring, which is my company business address for my public adjusting. And that's so that you know. And the process is called Payee notification. So if ever you needed to Google it. It notifies claimants whenever a settlement payment is made to both the insurance claimant and their representative, but is issued and or delivered to the claimant's representative. I suspect if they're mailing it to you, they don't need to let you know, but why not just make that a standard in all insurance companies? I'm sure that's what it is. But currently 14 states were required to do that, and Texas jumped on board. And they urge all parties and persons participating or engaged in the resolution of claims to use every prudent effort, including but not limited to the payee notification, to eliminate the instances of the misdirection, misapplication, or improper use of the insurance settlement monies. And maybe somebody stole your mail out of your mailbox. I don't really know. But I did have a customer, and her house had flooded and she wasn't living there. So the contractor lived across the street. He said, just have them mail the check over here to me. So it's I think his house, like the side of his house faced her house. So his house actually had a different street address, but it went over there. She didn't know anything about it. He and the public adjuster signed off on that check, forged her name, and deposited it into the bank, and she didn't know anything about it. And she thought she hired me because she didn't know that she had hired a public adjuster, because she really didn't. And so I don't know if the public adjuster knew about it. He's well known. I tried to let him know. I'm just going to put this out there. It ticks me off when anybody who wants to be a smart ass or wants to act like whether you're guilty or not, try to get to the bottom of things. So I just presume that maybe this contractor forged her name and this public adjuster didn't know, but he pretty much told me to go F myself, mind my own business. So, well, he got shut down. So anyway, when she hired me, State Farm went out there, she said, I did not get this check. They said, go file a police report. She did, for forgery. Then that allowed State Farm to go take that money back out of that bank account and then reissue the check. And so I don't know what happened. I don't know if the public adjuster got paid, who got screwed. I don't know. I don't care. But I know that's what happens because she didn't think she had gotten her check. Anyway, I just wanted to put that out there that anytime there's a settlement, whether you have a public adjuster or you have an attorney, you should be getting a payment letter in the mail. And I would presume, even though they're not supposed to reach out to you when you have a lawsuit, when you're represented by counsel, you still were or are they're insured, and they still have the right, that policy is a contract, they still have the right to send you material. Otherwise, how would you ever get your deck page or anything else when you renewed your insurance? So stay safe and be prepared. Call, like, subscribe. You can comment on here, and you can give me subjects, ask me questions, ask me to do a segment on something, and I will kindly oblige. Take care.